Morning, Your Honor.
You each will have 15 minutes, and you may reserve up to 5.
I would ask Your Honor to reserve 5 as well.
Thank you.
Thank you, Your Honor. May it please the court. We're here for oral argument on the appellate's brief on State v. Rosa.
Counsel, the only thing is I wanted you to stand behind the podium only because I want to make sure we're videotaping.
Oh, okay.
No, not there. Right here. Right here. It's fine. You were just sitting by the side. I apologize.
Oh, it's all right.
I'm just not sure we'll get you on camera. And we want you.
Oh, that's my problem.
Go ahead.
I was going to actually look over there.
That's why I was worried that you'd be on the other side of the room. Go ahead.
State v. Rosa was a failure to register and tampering with evidence trial last year. I am the appellate counsel assigned to the trial court. This was a 3-day jury trial, and what it really focused on was a couple different triangles. The appellant was indicted with failure to register his address based on a lease that he signed that said he was moving to a residence on the 1st of December of 2014. 10 days later, on December 10th of 2014, the appellant went to the Lorain County Sheriff's deputies came up to the appellant's registered home and verified that he lived with his cousin Myra. And fast forward a month and a half, midway through January, there is a not so anonymous tip that's called in that Mr. Rosa is not living at his registered address. The Lorain County Sheriff's deputies begin investigating him. Mr. Rosa had 3 residences involved in this case. At one point, he lived with his cousin, Myra. There's an address involved that is his girlfriend's address, and then there's his mother's address. So midway through January, the Lorain County Sheriff's deputies get a phone call that the appellant has changed his address. That phone call goes back to his girlfriend's husband, who's a off-duty Lorain Police Department officer. Deputies respond that day out to girlfriend's residence. Nobody answers the door. 2 weeks later, deputies go back out to the girlfriend's address. They say, walking through the hallway, a male that we can't identify resembled the appellant. That is the start and the foundation for this indictment. And the 3 appellate assignments of error, one of them was on indictment dates in Criminal Rule 7. The second was on a sufficiency, but a sufficiency of a Rule 29 motion for dismissal at the end of the state's case, and then a manifest weight argument. The second assignment of error, the sufficiency at the end of the Rule 29, I think is probably Mr. Rosa's strongest argument. Throughout the trial, this is a very bizarre. Mr. Rosa signed a lease to live with his girlfriend. At the trial, the landlord of that residence came in and said he signed it on November 31st. But the apartment was not move-in ready. So in that meantime, after Mr. Rosa signs the lease, his girlfriend moves in. In that preceding month and a half, Mr. Rosa finds out that he can't live there because there's a daycare center that is prohibited him as a sex offender from living there. At trial, and this goes back to sometimes the defendant's testimony is the most damning. What the defendant testified on his own behalf in the defense's case. He actually testified to that he changed his address to his grandmother's house on February 2nd. He registered this address on January 30th. And if you look at the verdicts, there is a failure to change address that occurred on December 1st. There is a tampering with records that happened on December 10th. So December 1st, the state relied on the fact that Mr. Rosa signed his lease with this landlord moving out of his house. That is the extent of the evidence presented that Mr. Rosa changed his address was this lease. Now, the landlord testified that it wasn't move-in ready, that he actually was offsetting rent because they were doing renovations. Nobody can put him in the house that was brought as a witness for the state or determinative ID. There's no other outside witnesses. December 10th rolls around, that's when the sheriff's deputies come out to the house. They said the sheriff's deputies presented the records that said Mr. Rosa still lived there. He verified that. That is the extent of the evidence against the appellant up to his own testimony. When I say substantive, there was 5 witnesses presented. There was 2 detectives from the sex offenders unit. One of those detectives verified that he lived there on December 10th. The other one took the anonymous tip. Myra Hernandez, the cousin of the appellant, came in and he testified, or she testified. She originally told deputies that he moved out December 1st, but later testified that he probably moved out sometime in December or January. And at the close of the state's case, what the appellants are arguing is that when defense counsel made his motion for Rule 29, in the light most favorable to the state, there was not enough evidence. After the Rule 29 motion was denied, that is when the appellant came to the stand. He testified and kind of opened the door on things that happened in the end of January. Demonstrative that is what the jury found. The jury found the appellant not guilty on the tampering with records on December 10th. They did find him guilty of failure to register because at the end of the case, the state amended the indictment from December 1st, 2014 to January 31st, 2015. And that kind of segues into the next assignment of error that the appellant filed, which was that I used State versus Vitale, which is an 8th district case, and then I used this court's decision in State versus Bennett to show that these are 2 separate cases, or 2 separate factual situations with only one of them going to the grand jury. The first factual situation was the December 1st change of address and the tampering. At trial was developed that the appellant didn't change his address on January 30th of 2015. In that assignment of error, I used State versus Vitale's arguments that it was 2 separate crimes. The second crime, because it came out with the defendant's own statement, was first presented at trial. It was never presented to a grand jury. Then I also would like to point out the State versus Bennett, which was this court's decision where it was a mentally impaired robbery victim. And there was questions on the dates of the indictment. And I believe in the discovery at the trial, the indictment, it was a robbery that occurred, just say, June 1st. At trial, it gets developed to be June 15th. And counsel in that case for the appellant came in and said, hey, this is 2 separate factual patterns. And this court distinguished it by saying, no, this is a change in circumstances that it's one crime happened, it's just we couldn't put down a date and solidify that it happened June 1st, it happened June 7th. That is why counsel brought that up, was because of that important distinction. These are failure to register, failure to change address that occurred when Mr. Rosa was going from cousin to girlfriends and then cousins to his mom's house. And those additional facts were not presented to the grand jury. There was no indictment made on that. And then the third assignment of error the council filed was a manifest weight argument. And that was based on the totality of all the witnesses who testified, including the defendant, and the upon which factors. So in this case, there is actually no solid identification or testimony saying that the appellant ever moved from his residence with cousin to this address with the girlfriend. We have a tip that was called in from a girlfriend's husband at the time. We have testimony from one of the deputies. I couldn't make a definite ID when I stopped at the house, but a male was in the house who resembled Rosa. And really, in light most, I know that's sufficiency, but in the light most favorable to the state, that's about the extent of putting Mr. Rosa in that house. There was no.
And you're in your area.
Thank you.
Up to you. My name is Natasha Lorain. I represent the appellate of the state of Ohio on this matter. First to start with the sufficiency argument. The testimony was that there was a tip that came in on January 14th, 2015 with regards to the fact that Mr. Rosa was no longer residing at this East 35th Street address, which is with his cousin where he registered, but in fact was living at this East 35th Street address. The deputy went out to the East 31st Street address, was able to see in the windows, saw some furniture, some clothing, and actually was able to find the phone number to the landlord of that residence. The deputy then called the landlord, and the landlord was able to confirm that Mr. Rosa and his girlfriend both signed a lease for that particular residence. He stated that it was signed on November 31st, but that the terms of the actual lease stated that that the two of them could move in anytime after October 31st of 2014. And that there was some agreement to do some additional work on the residence to be ready for December 1st. The deputies, both deputies then, on January 30th of 2015, again reported back to that East 31st Street residence. And that was then when they just saw somebody who appeared similar. They could not say that it was Mr. Rosa in the residence. They then went from there to the 35th Street residence where Mr. Rosa was actually registered and spoke to his cousin at that point in time. The cousin provided to them, Mr. Hernandez, that Mr. Rosa had in fact moved out on December 1st of 2014. And it was based upon that information that the indictment was then stated that as being the date of December 1st of 2014 based upon the information that Ms. Hernandez provided. Ms. Hernandez did testify on behalf of the state. She stated she did confirm that she in fact provided that information to the deputies at that point in time. And although during her testimony she somewhat retracted in saying she couldn't provide a specific date during her testimony, but he did in fact move out in sometime in December or January of 2014. And the state would request that this court look at State versus Treadwell, which is out of this district. Somewhat similar fact pattern in that in Treadwell, the deputies got some information again that Mr. Treadwell was no longer residing at his registered address. They spoke to the landlord. Landlord provided information that Mr. Treadwell moved out in July of 2011. And that was the basis of the indictment. During trial, the landlord actually testified, stated that he never actually talked to the deputies back then, never provided that information to them. And the defense counsel actually provided some sort of statement that the landlord wrote out saying that Mr. Treadwell actually moved out in September of 2011. However, during his testimony, The landlord did in fact indicate that he could not provide a specific date as to when Mr. Treadwell moved out and may have been mistaken as to the September date. And based upon that evidence that was presented, this court did in fact find that there was sufficient evidence to prove that Mr. Treadwell did in fact fail to register a change in his address. And the state would submit that those are in fact similar facts to what we have here, and that Ms. Hernandez provided a specific date to the deputies. She then kind of retracted, as the landlord did in his testimony, but that the jury did in fact, was presented with sufficient evidence in order for them to convict Mr. Rosa of the failure to register his address. In second, with regard to the manifest weight argument, there was no indication, in fact, that it was the girlfriend's husband that provided the tip. Deputy Ashmeyer actually testified that it was an anonymous tip that was received, and there was no indication that, in fact, that was from the girlfriend's husband. And also, with regard to the Talley case that was cited by Mr. Rosa in his brief, the state would submit that it's distinguishable from what we have here. And with Talley, the indictment was in fact amended in order to include a week-long period of time. And during that period of time, there were actually 2 theft offenses that the defendant could have been indicted for, 2 separate offenses, and therefore, because of that enlargement of time, it was determined that that was improper. Here, we never, because it was there could be a chance for a different crime. Here, that's not the case. Here, the charge against Mr. Rosa is and always was his failure to register a change of his address from his registered address to whatever new address he had. And in fact, it's not for the state to prove that he had a new address, but only that his old address was no longer valid, which was done here through the testimony of the deputies, through the testimony of Mr. Hernandez. The manifest weight of the evidence did in fact support his conviction in this matter. And finally, with regard to the actual amendment of the indictment here, the trial court correctly did that as well, in that he relied upon Rule 7D, which allows the trial court to amend an indictment before, during, or after a trial based upon the evidence that was presented. And again, Ms. Hernandez testified to the fact that Ms. Rosa moved out of her residence. During trial, her testimony was not a specific date, but sometime during December or January, and therefore the trial court correctly amended the indictment to reflect that evidence that was presented to the jury. Therefore, the state would request that this honorable court uphold the conviction and sentence of Mr. Rosa in this matter and overrule Mr. Rosa's 3 assignments of error. Thank you. Thank you, Your Honors.
Thank you, and may it please the court. In rebuttal, with the Criminal Rule 7 amendment, the state's argument in this is the equivalent of being in Summit County and having an OBI that is alleged to occur on June 1st in Richfield, and then coming to trial in municipal court 2 months later, and then there's the defendant gets out and he's like, I haven't driven drunk in Richfield, but man, I was blasted a couple nights ago in Stowe. Up until the trial date, there was no evidence to establish any failure to change address until it was developed by the defendant on the stand. The indictment says December 1st because that was the day the state alleged that Mr. Rosa moved from cousin's house in with the girlfriend. The tampering with records was December 10th because that's when the sheriff's deputies came out. Now, that's how it segues into the sufficiency argument, is the jury found that when the sheriff's deputies came out to the cousin's house and talked to Mr. Rosa, that at that point he was living with the cousin and found him not guilty. Now we have when the case ends and the Rule 29 motion is made for an acquittal, it's denied. Now, when the appellant takes the stand and he testifies about his later move from cousin's house to his mother's house, he did that with 3 days' notice in violation of the failure to register address. You can actually kind of read through it. When you read through the transcript, you can actually see after the appellant while the appellant's testifying, you can hear him stating how he moved from his cousin's house to his mother's house and then backing off of that. And when you look at this case as a totality, then it makes sense why they did not find guilty on the tampering of records that happened after the original change in address. And that amendment was made in violation of Criminal Rule 7 because I understand the state's argument that, hey, this isn't like a robbery with Tommy as a victim and we come to trial and we change it to Stevie is a victim. I understand that argument, but in this case, you have a change from, hey, he wasn't living here December 1st to, hey, now we have a 2-month time frame and somewhere in there he didn't change his address correctly. Why? Because you're taking into account facts that were never presented to the grand jury. Because the defendant never gave any statements until he was at the trial. And the proper course is to send that back down. And the state can use that testimony, present it to the grand jury and decide if they want to return an indictment on that. Not what we have here. These are two separate fact patterns. This is just like an OBI doesn't have a victim, but this is like amending that OBI. So when the defendant says, yeah, I've never Richfield, but man, I was blasted driving in stone. That's what this is. And look at the sufficiency, and you can see. If you look at the sufficiency, the facts that show during the time frame, what do we have that Mr. Rosa actually lived with his girlfriend?
Thank you, counsel. Thank you. Thank you both. The court will take the matter under advisement. A written opinion will be sent to both sides, and you can look on the website or release it electronically. Thank you.